Good day everyone. Our topic today is Presidential Decree number 968 of July 24, 1976, establishing a probation system, appropriating funds thereof, therefore and for other purposes. Section 1. Title and scope of the decree. This decree shall be known as the Probation Law of 1976. It shall apply to all offenders except those entitled to benefits under the provision of Presidential Decree and numbered 603 and similar laws. Section 2. Purpose. This decree shall be interpreted so as to promote the correction and rehabilitation of an offender by providing him with individualized treatment. B. Provide an opportunity for the reformation of penitent offender which might be less probably if he were to serve a prison sentence. C. Prevent the commission of offenses. Section 3. Meaning of terms. As used in this decree, the following shall, unless the context otherwise requires, be constructed thus. A. What is probation? Probation is a disposition under which is a defendant, after conviction and sentence, is released subject to condition imposed by the court and to the supervision of probation officer. So, ang probation daw po ay binibigay ng court at meron siyang probation officer na nag-guide sa kanya. Ang probation ay binibigay sa mga mababang may sentensya ng 6 years below. Probationer means a person placed on probation. Probationer officer means one who investigates for the court a referral for probation or supervises a probationer or both. Ang probationer po ay yung taong convicted na nakagawa ng kasalanan na nahatulan na ng less than 6 years. At ang probation officer ay ang kanyang guide. Section 4. Grant of probation. Subject to the provision of this decree, the court may, after it shall have convicted and sentenced a defendant, and upon application at any time of said defendant, suspend the execution of said sentence and place the defendant at probation for such period upon such terms and condition that it may deem best. Section 5. Post-sentence investigation. No person shall be placed on probation except upon prior investigation by the probation officer and a determination by the court that the ends of justice and the best interest of the public as well as that of defendant will be served thereby. Ang post-sentence investigation ay magkakaroon ng investigation sa probationer kung pwede ba siyang bigyan ng probation. Ang probation ay yung mag-sentence ka ng sentensya mo sa labas ng kulungan pero may mga condition pa rin. Form of investigation report. The investigation report to be submitted by the probation officer under section 5 hereof shall be in the form prescribed by the probation administrator and approved by the Secretary of Justice. Form of investigation report ay report na ipapasa ng probational officer to the Secretary of Justice para mabigyan ka ng probation. Period of submission of investigation report. Ito naman yung merong ang probationer meron siyang 6 days para maipasa yung form of investigation na ginagawa. Tapos yung court naman meron lang siyang 5 days para magawa. Section 8. Criteria for placing an offender on probation. In determining whether an offender may be placed on probation, the court shall consider all information relative to the character, antecedents, environment, mental and physical condition of the offender, and available institutional and community resources. Probation shall be denied if the courts find that the offender, ito yung yung criteria na kung pwede kang ilagay sa probation. A. The offender is need of correctional treatment that can be provided most effectively by his commitment to an institution. Kailangan ng correctional treatment. Kailangan ng offender the offender is need of correctional treatment that can be provided most effectively by his commitment to an institution. Either be this undue risk that during the period of probation, the offender will commit another crime. C. Probation will depreciate the seriousness of the offense committed. Yun po yung criteria para mabigyan ka ng probation. Section 9. Disqualified offenders. The benefits of this decree shall not extended to those. Ito na po yung disqualification ng disqualification ng offenders to avail the probation or to get the probation. A. Sentence to serve maximum term of imprisonment of more than 6 years. Pag 6 years and 1 day ka na ang sentensya mo, hindi ka pwede mag-avail ng probation. Convicted of any offense against the security of the state. Yan, crimes against security. Who have previously been convicted by final judgment of an offense punished by imprisonment of not less than 1 month and 1 day and a fine or not less than 200. So parang ito yung halimbawa dati ka nang na-convict less than 1 month, hindi ka makaka-avail ng probation. D. Who have been once on probation under the provision of this decree. Letter E. Who are already serving sentence at the time of substantive provisions of this decree became applicable person to Section 33 hereof. Ito yung nag-serve na dati ng probation, tapos nakulong ulit sa gabi ulit din na pwede. Section 10. Condition of probation. Every probation order issued by the court shall contains conditions requiring that the probationer shall. Ito yung condition ng probation, yung limit na gagawin mo kung mag-serve ka ng probation sa labas. Sa labas naman talaga ang probation. Letter A. Present himself to the probation officer designated to undertake his supervision at such place as may be specified in the order within 72 hours for receipt of said order. So, kailangan mong report sa probation officer na binigyan ka lang ng 72 hours or 3 days, I think siguro. So, yung depende sa binigay sa'yo ng probation officer mo. Dapat kailangan mong report. Letter B. Report to the probation officer at least once a month. Kailangan mong report sa probation officer mo once a month, tapos yung binigay niyang oras at lugar. The court may also require the probationer to cooperate with the program of supervision. Pag-cooperate ka sa program of supervision. Tapos section 11. Effectivity probation order. A probation order shall take effect upon its issuance, at which time the court shall inform the offender of the consequences thereof and explain that upon his failure to comply with any of the conditions prescribed in the said order of his commission of another offense, he shall serve the penalty imposed for the offense under which he has placed on probation. Section 12. Modification of condition of probation. During the period of probation, the court may, upon application of either the probationer or The probation officer revise or modify the condition or period of probation. The court shall notify either the probationer or the probation officer of the filing application so as to give both parties an opportunity to be heard on. So, pag mayroong babaguhin dun sa probation, kailangan mag-apply sila, mag-fill up ng application, tapos bibigay sa court. Section 3, Control and Supervision of Probationer. The probationer's probation program shall be under the control of the court who place him on probation subject of total supervision and visitation by a probation officer. So, sa section 13, meron control and supervision of probationer. So, meron sa kanila nagbabantay tapos nagsusupervise kung ano mga ginagawa nila. Section 4, Period of Probation. The period of probation of dependent sentenced to a term of imprisonment of not more than 1 year shall not exceed 2 years, and on other cases, said period shall not exceed 6 years. Section 15. Arrest of probationer. At any time during probation, the court may issue a warrant for the arrest of a probationer for violation of any condition of probation. So dito pag merong violation na ginawang probationer, pwede siyang ma-convict ulit, tapos magkakaroon ng sentence. Tapos the court shall order the probationer to serve the sentence originally imposed. So, maaari siyang bigyan ng ibalik siya sa loob ng kulungan at hindi na siya bigyan ng probation dahil sa di siya sumunod sa condition. Termination of probation, Section 16. After the period of probation and upon consideration of the report and recommendation of the probation officer, the court may be ordered the final discharge of probationer upon finding that he has fulfilled the terms. So, maaaring nang matapos yung probation mo pag okay naman yung performance mo, nagawa mo naman lahat ng mga condition. Section 17, Confidentiality of Records. The investigation report and the supervision is to the probation officer. Probationer obtained under this decree shall be privileged and shall not be disclosed directly or indirectly to anyone or other than probation administration or the court concerned. Section 18. Probation administration, there is hereby created under the Department of Justice an agency to be known the probation administration, herein referred to as administration, which shall exercise general supervision over all probationer. So, ginawa ito sa ilalim ng Department of Justice na tinatawag na probation administration. Section 19, Probation Administration. The administration shall be headed by the probation administration, who shall be appointed by the President of the Philippines. He shall hold office during good behavior and not remove except one. So ito, the administration shall be headed by the probation. Mas pataas tong probation administration. Isa dito sa probation administration, magkaiba yung dalawa. Section 20, Assistant Probation Administration. There shall be an Assistant Probation Administration who shall assist the administration. Ito yung halimbawa papalit sa the administration pag wala silang duty, kaya of duty sila. Section 21, Qualification of the Administrator and Assistant Probation Administration. To be eligible for appointment as administration or assistant probation administration, a person must be at least 35 years of age. Yan yung mga qualification para magkapagtrabaho sa administration o maging isa kang administrator. Correction, Penology, Psychology, Sociology, Public Administration, Law, Police, Science, Police Administration, or related fields o yung mga related dun sa probation. You should have at least 5 years of supervisory experience. May experience ng 5 years. Section 22. Regional Office. Regional Probation Officer. The administration shall be regional offices organized in accordance with the field service area pattern established under the Integrated Recognition Plan. Section 23. Provincial and city probation officer. There shall be at least one probation officer in which province. Sa provincial and city probation, meron siyang at least one probation officer in each province na in-appoint ng Secretary of Justice and nirekomenda ng administration ng administrator. 24. Miscellaneous power of provincial and city probation officer. Provincial or city probation officer shall have the authority with their territorial jurisdiction to administer oaths, acknowledgement notes, disposition in connection with their duties and function under this degree. They shall also have, with respect to the probationer under their care, the power of police officer.